Hello and welcome. This VPAL signature event is brought to you by Harvard's Office of the Vice Provost for Advances in Learning in partnership with Harvard Online and the Harvard Alumni Association. I'm pleased to welcome our speaker this evening, Noah Feldman. Without further ado, Noah, the virtual floor is yours.
Thank you so much, and thank you to all of you who are joining. My topic today is the rule of law wars, and that topic starts with specifically the inauguration of President Donald Trump for his second term in January of 2025, so approximately 15 months ago. And my job today is to try to give you a kind of overview of what has happened with respect to the rule of law in the United States during that period of time, some highs, some lows, and an analysis of who are the different institutional actors who are participating, and some tentative view of where we are going. So that's the overview. And what I want to begin by saying, just in order to define our terms, is that I'm defining the rule of law, which is the key term for our conversation today, as the structure whereby the government of the United States, federal, state, and so forth, local, operates according to specified legal norms in the Constitution and in statutes that are widely recognized by the relevant political actors in the executive branch, in Congress, in the judiciary, as well as by the public as binding and as normative. And ultimately, all of those legal norms trace back to the Constitution. But again, it's not only about constitutional issues, it's also about federal laws and state laws that are part of the picture as well. And the starting point for my talk is to acknowledge that not since the opening days of the first term of the presidency of Franklin Delano Roosevelt, which started in March of 1933, has there been a president who's tried so many initiatives that were received by the other branches of government and by parts of the public as actively deviating from what were understood to be constitutional norms. And probably the biggest difference between FDR's initiatives and Donald Trump's initiatives has been that FDR's initiatives were supported by a Congress that wasn't just majority Democrat, but had a large, very large Democratic majority in both the House and the Senate. And also that Roosevelt had been elected in a landslide. And so in that important respect, Roosevelt enjoyed much greater political support across the full spectrum than Donald Trump has done. Also, at the same time, FDR faced a Supreme Court, which was not made up of a majority of justices who were sympathetic to him and had no justices that he had appointed since he had actually just become president, and he actually didn't get even to appoint any justices in his first term as president. In contrast, Donald Trump is now in his second term as president, and so there are 3 justices on the court whom he appointed, as well as another 3 justices, so a total of 6 justices who were appointed by other Republican presidents. So that's to set the framework and the context. And so I want to emphasize that to the extent I can, what I'm describing as the Trump administration's attack on the rule of law, I'm really trying hard not to frame that in a highly partisan terms. There's inevitably some ideology in this, as we'll talk about, but I'm trying to not make it partisan. And in part, that's one of the reasons that I want to begin by contextualizing and saying that if you had asked Republicans who were opposed to FDR's actions in his first term in office, and especially at the beginning of the first term and the enactment of the so-called First New Deal, they would have seen challenges to the rule of law every bit as significant and in certain respects greater than opponents of Donald Trump's presidency have seen as well. So that's a setting up with a little bit of historical context. Now, who are the actors who have been responding to Trump's actions, and what have those actions been? So let me just describe the dramatis personae, and then I'm going to start talking about the specific players. About the specific actions on the Trump administration's part. I'm going to talk mostly about Congress, about the courts, and about the public. And public is always a difficult term to define, so I'll be looking both at polls and also at public forms of activism, and I'll also mention the press to some extent in that context as well. So those are the players, the actors in the drama that I'm going to be describing. Now, what have been primary examples of Trump's deviation from what had been understood as the rule of law? Well, they started very early in the Trump administration with executive orders, some of which immediately flew in the face of what were understood to be existing legal norms. A prominent example that's only recently finally come to the Supreme Court was the Trump administration's executive order on birthright citizenship, declaring that children of undocumented people born in the United States were not citizens, notwithstanding what had previously been understood to be the plain textual meaning of the 14th Amendment that says that people born in the United States and subject to the jurisdiction thereof are citizens of the United States. So that would be one clear example. Another example, more controversial, would include DOJ's efforts to shut down significant parts of the executive branch, including significant parts of the Department of Education, including USAID, and then firing many, many officials across the government. Those were all challenged in court, and as we'll see in a moment, the courts have reached a range of different decisions about different parts of that, but all were challenged and all were new. They were all things that the Trump administration claimed were consistent with law, but opponents denied were consistent with the law. Along the way, we also saw pretty early on presidential actions that, at least to observers who didn't like them and who objected to them, were interpreted as violations of the freedom of speech. So that would include open targeting of lawful permanent residents in the United States and people in the United States on student visas for the removal of their visa status, of their lawful visa status on the basis of their speech, notwithstanding a long set of legal norms that treat lawful permanent residents as having full First Amendment free speech rights, as well as actions targeting law firms that Donald Trump was angry at, and universities, including, and this is relevant since you can see from the screen, this is a Harvard-sponsored event. I'm a professor at Harvard. I'm sitting in my office at Harvard, so can't avoid talking about Harvard, including an attempt to shut down a tremendous amount of government funding that goes to Harvard, all of it in the form of grants that Harvard faculty had earned in competitive grant-making processes, primarily, though not exclusively, in the sciences and the social sciences, which, again, I'll get to this, were challenged in court by Harvard University, as were the sanctions placed upon law firms, and at least at the district court level, the courts ruled against the Trump administration. Again, I'm going to come to those things. Then, over the course of the remainder of the last 15 months, there have been a range of other actions, most prominently the deployment of National Guard troops in a bunch of cities and states, primarily Democratic cities and states, and finally, and notably, the deployment of ICE personnel to detain undocumented people using procedures that potentially extended beyond undocumented people. Those have also been challenged in court, and I'm going to talk about those as well. This all culminated in Minneapolis, Minnesota, in the efforts that, among other things, included the deaths of 2 U.S. citizens in confrontations with ICE agents, which I'll also come back to. And then very finally, and this will be the last thing I speak about, is President Trump's bombing of Iran and commencement of what I think we're now openly calling our war against Iran without congressional authorization, notwithstanding both the Constitution's requirement of congressional authorization for making war and also the War Powers Resolution. So that's the kind of overview of the kinds of actions by the Trump administration I'm going to be talking about. What I'm going to do is try to go through those and describe the responses made by the different political and legal actors to try to give an overview of how it's going, as I said, where we are and where we're likely to go. So, point one, in particulars, these actions were almost all fully unprecedented. But at the general level, it's fair to say that significant presidential action uh, at the beginning of a presidential administration is not totally unprecedented because of Franklin Delano Roosevelt's presidency. So, Roosevelt engaged in, to some extent, executive actions that had to do with the supply of gold in the United States and had to do with banking in the United States. And Roosevelt then subsequently, and those were challenged in court. Roosevelt also subsequently Congress passed and Roosevelt signed the so-called First New Deal, which ultimately was struck down by the Supreme Court. And there was a tremendous amount of controversy around those actions. So again, the idea that a president would take such steps is not on its own unprecedented, but the particular steps that the Trump administration took have almost all been unprecedented. And as we shall see, that's been one of the features of the court's response. So let's start with Congress, which is, after all, the people's branch of government. And the question I just want to ask is, how has Congress done and how has Congress responded to these presidential actions? And I want to begin by noting that at the beginning of the administration, the DOGE cuts were largely cuts that contradicted congressional statutes that had established the relevant government offices, like the Department of Education, like USAID, and that were spending money based on congressional authorizations. And it would have been natural for Congress to be the first actor to respond to those before even the courts by taking action to try to ensure that these closures were not legally ratified or were in fact even contradicted. And it's noteworthy that the Republican-dominated Congress did not take that step for the most part, did not choose the pathway of direct confrontation with the president. But when it came to reauthorizing various things that the president had cut, science funding most notably among them, the Republican Congress, with Democratic votes as well, has, to a remarkable degree, gradually reinstated many of the forms, though by no means all of the forms of funding that the Trump administration broke on its own. So it would be fair to describe Congress as taking an oblique or an indirect approach, not confronting Donald Trump at the beginning of his presidency, which is perhaps understandable given that the majority in Congress is from the same party as the president, but also taking some indirect or oblique steps to restore some programs that the Trump administration seemed to cut. And this suggests that for the future, should a future president, Republican or Democrat, take steps that actively seemed to resist the allocations of funds created by Congress, and or to close institutions established by congressional enactment and laws that were binding, it may well be that Congress doesn't in the future stand up directly to such a president, assuming the president is from the same party as the majority in Congress, but that the party may engage, as the present Congress has done, in some back-end action to try to reduce the impact of those actions. And what that suggests to you, or at least what it suggests to me, is that political norms of partisanship in which the party of the president seeks very strongly to support the president are, at this moment in historical time, more powerful than Congress's interests as a branch of government in enforcing its own prerogatives as a branch of government. So let me make that clear. In the tripartite system of government established by the Constitution, as justified by James Madison, Alexander Hamilton, and the Federalist Papers, the theory of the separation of powers relied pretty heavily on the idea that members of Congress would be jealous of the president exercising powers that belong to them, and would act to preserve their own powers. You can imagine here the famous line from the Federalist Papers, ambition must be made to counteract ambition. The idea here is that there's a balance between the different branches of government, because if the president of whatever party takes action that reduces the power of the Congress of whatever party, Congress will respond. And I think it's fair to say that under current conditions of partisanship, that balance of powers is substantially weakened when it comes to a Congress that belongs to the power of the president. And I think it's extremely important to note that, because the Constitution as originally drafted was not based on the assumption that the rule of law would primarily be defended by the courts. It was also not based on the assumption that the rule of law would secondarily be defended by the public. I would say it was based on the idea that initially and primarily the rule of law would be protected by Congress against executive action that seemed to violate the rule of law, and the courts would become involved only if Congress did not take steps or did not take sufficient steps, and that the public would become involved really only if those institutions on their own had failed. This is particularly true because in the original constitutional design, the Congress was meant to act on behalf of the whole people. So I think, I can't state strongly enough here that one of the important takeaways of the first 15 months of the Trump administration is that under current conditions of partisanship, which could change, but at present seem pretty well instantiated, it's pretty difficult to deny that the separation of powers as designed by the framers is not working the way it was meant to work when the party of Congress, the majority in Congress, and the party of the president are the same party. Okay, so that's an assessment of Congress. I would say that the other area where Congress has played, could have played a much more significant role, and largely has not, is in the context of the Iran war. Here, there was talk in Congress of introducing a war powers resolution and trying to get it passed. Such a resolution would have said that the president had engaged in hostilities under terms of the War Powers Act, and therefore that the calendar was ticking to the period of time beyond which the president would not be acting under congressional authorization without a specific congressional act to authorize the hostilities. And that has not passed Congress. Even had it passed Congress, it probably would have been, probably still would have been vetoed by the president, but it hasn't even passed Congress. So again, the basic explanation for this is surely the Republican majority in Congress. And here too, it's actually somewhat hard to imagine that a Democratic Congress with a Democratic president who had initiated hostilities of the kind we've initiated in Iran would have insisted on constraining or limiting the power of the president. And that's another indication that the separation of powers model is not working the way the framers imagined that it would work. Again, you can't state strongly enough that from the perspective of the framers, going to war against another country, and the United States is by any rational standard at war with Iran, was only supposed to happen if Congress declared war. That's why the Constitution gives the power to declare war squarely to Congress. The president is the commander-in-chief. Once a war is declared, he gets to run the war. But going to war was supposed to be the decision of Congress. Now, the framers were pretty confident that Congress could enforce that principle on its own without the courts. And the reason for that was the United States in its early days did not have a standing army, had a tiny, minimal navy. And so if it was going to invade another country or go to war with another country, Congress would have had to allocate the funds to raise an army and to expand the size of the Navy. So there would have been no way for a president to take the United States into war and sustain the war without direct and immediate support from Congress. That became less and less the case over the course of the 20th century, and particularly after World War II, after which we ended up maintaining a substantial standing army. And as of the present, it's pretty clear, and the Iran war is an extraordinarily clear manifestation of this, that the United States can enter into protracted hostilities with a foreign nation that cost a tremendous amount of money, that involve lots of different parts of the military, that put American troops in jeopardy, and get away with it. There's a technical question about whether the War Powers Resolution even applies here. I'm not getting into that now. I'd be happy to talk about it in the Q&A if people are interested in it. But rest assured, from my perspective, that it's very clear that the War Powers Resolution does apply here, even though the legal precedent for claiming that it didn't actually came from the Obama administration's claim that when the United States bombed Libya, doing so did not trigger the War Powers Resolution because bombing from the air did not, quote unquote, count as hostilities. That's a position that the Obama administration ultimately adopted. I think it was fundamentally wrong, wrong legally, wrong practically, and you can see why now. But again, happy to talk more about that in Q&A if you wish. So the verdict for Congress is not very interested in protecting the prerogatives of Congress, and therefore willing to allow deviations from what otherwise might have been construed as the rule of law. So let me turn now to the courts. The federal district courts have been functioning as the front line in the war that I'm describing, the war on the rule of law. Because Congress hasn't been acting, it means that pretty much anyone who's affected by Trump administration action and can credibly allege that those actions have violated either statutory or constitutional norms goes to a federal district court and seeks an injunction blocking the executive branch from doing whatever it is that it has done. In a meaningful number of cases, a really significant and meaningful number of cases, the federal district courts have blocked Trump administration action that they saw as unlawful. It happened prominently in the case of Harvard University, where a federal district judge in Boston blocked the Trump administration's initial legal efforts to suspend funding to Harvard. There's a subsequent case brought by the Trump administration in that same federal district court, this time following the rules of Title VI, under which a judicial finding of anti-Semitism would be necessary before some limitations on funding could be put into place. But the key point I'm making here is that the federal district court did stand up to Donald Trump and did so relatively quickly after the initial case was filed. Similarly, federal district courts blocked the Trump administration's actions against the disfavored law firms. Some federal district courts, in some instances, also intervened to block some of the firings of federal employees and some of the limitations on government funding. Those have been appealed up to the US Supreme Court, and I'm going to come to the Supreme Court in a moment, but I think the overview is that the Supreme Court has had a mixed record on that. In some cases, saying that the Trump administration could not do what it did, but in other cases holding that, especially involving money dispersed by the Trump administration that was no longer going to be dispersed, that the cases had to be brought in the Court of Federal Claims, which adjudicates contract disputes between citizens and the government, which effectively amounted to, at least in the short term, a victory for the Trump administration because it meant that the federal district courts couldn't step in and just bar that action. So those cases, the federal district courts were fairly aggressive, and the Supreme Court upheld some of those things and has struck down many others. So that's yet a second domain. When it comes to detention and also removal of non-citizens from the United States, the lower court's record is also pretty impressive. Many federal district courts have blocked specific detentions and have blocked specific removals. And here, there was a well-publicized set of circumstances in which some number of detainees were removed from the United States to El Salvador. These were Venezuelans, were removed from the United States to El Salvador, even after federal district judge James Boasberg in Washington, D.C. had issued an order that they not be removed. The appellate courts and the Supreme Court in that case really have tried to avoid direct confrontation between the judiciary and the executive branch. They've kind of ducked the issue. And the reason they've ducked the issue, just to make it very clear, in my view, is that they're worried that if the Trump administration were directly ordered to return people to the United States who are outside the jurisdiction of the United States, and the administration, the Trump administration, refused to do so, that would amount to direct defiance of a judicial order. And in the complex game that is being played between the courts and the executive branch, the courts are afraid that the Trump administration might actually deny a lawful order. And if that happened, and the courts were unable to force the president to comply, that would very substantially undermine the power and capacity of the judiciary. The judiciary does not want that to happen. They do not want a case to arise in which the Trump administration, the executive branch, says, we're ignoring you. If they did so, if the executive branch did so, that could constitute the basis for a constitutional crisis. And the courts don't want a constitutional crisis. So they've tried to duck the issue. That said, Judge Boasberg hasn't completely let the issue go. And he's been interested in trying to figure out if there are specific officials who can be found in contempt. So he has preserved the issue. Broadly speaking, though, the account that I'm giving is one in which the district court judges have done very, very well overall at standing up for what they perceived to be existing legal and constitutional norms. The Supreme Court, I would say, has done less well. And my point is not that the Supreme Court wasn't sometimes arguably correct to say that some of the cases couldn't be adjudicated in the federal district courts, although in my own view, the federal district courts are the right place to adjudicate such violations. It's more that the job of the Supreme Court is to function as generals in the war against the rule of law, generals in defense of the rule of law. And generals need to take account of the morale of their soldiers in the field. And in this metaphor, the district judges are the frontline soldiers, and the Supreme Court justices are the generals. And instead of consistently standing behind the district court judges, the Supreme Court justices have on a few occasions, pretty well publicized occasions, actually undermined the federal district judges, among other things by complaining publicly that the district judges were not following doctrine that the Supreme Court was establishing. But the Supreme Court wasn't establishing this doctrine the way it usually does it, through reasoned opinions published by the Supreme Court after cases that have been properly briefed and argued. Instead, the cases arise on the court's emergency docket, sometimes called its shadow docket. The court issues opinions that are very hard to follow, that are sometimes very incompletely reasoned. And they're very hard to follow for district court judges. And so in the handful of cases where the Supreme Court justices were frustrated, or some of the justices were frustrated, that the lower courts hadn't listened to what they wanted to do, I think the Supreme Court really undermined the capacity of the frontline judges to fight their corner in the fight for the rule of law. And in my view, that was a real failure on the part of the Supreme Court. However, and there's a significant however here, in recent months, the Supreme Court has also taken significant steps to try to enforce the rule of law. And the most visible and significant context for that was the tariffs case. So here, in a case where whatever the Supreme Court decided, it was going to be enforced, the Supreme Court struck down by a 6-3 majority, with Chief Justice John Roberts and Justice Amy Coney Barrett as part of the majority, the tariffs that Donald Trump had enacted as his signature domestic and foreign policy initiative. That was a hugely significant decision. You have to go all the way back to the time when the US Supreme Court invalidated the first New Deal, which had been enacted by Congress by a large majority and signed by FDR, to find another instance where a president's premier policy initiative was fully struck down by the Supreme Court. President Obama's Affordable Care Act was partially struck down by the court, but also partially sustained. That was a different thing. So it was quite significant to see the Supreme Court standing up to President Trump in that way, significant historically and significant practically. And so, again, seen from that perspective, you could describe the Supreme Court as having taken a much firmer stand in defense of the rule of law in recent months than it had done previously. Now, it does not escape anybody's attention that the tariffs case is not a case involving the least privileged people living in the United States, undocumented, residents, but rather involves general interests, but it also involves corporate interests. So I'm not trying to suggest here that the Supreme Court has suddenly turned into defender of the least fortunate in this instance. But I think at the same time, it is crucial to acknowledge that the court, in a non-ideological, and if you look at the party of the appointing president, nonpartisan decision, did meaningfully constrain presidential power under the theory that the president's actions were not in conformity with statute and therefore were not in conformity with the US Constitution. Um, and that's, I really think it's fair to say that that's enormously significant. I, by the way, neglected to mention Justice Neil Gorsuch, whom I should have mentioned, was also part of the six-justice majority there. So I'm just repairing that. Justice Gorsuch actually wrote an opinion emphasizing that in his view, the Supreme Court had to step in because Congress had not delegated properly to the executive the opportunity to impose tariffs of that kind. And indeed, in Gorsuch's view, it could not do so under exactly those conditions. So the court's record today is substantially better than it was, say, at the beginning of January 2026. And I think that has to be taken into account and has to be taken seriously as part of the analysis that I'm offering. Okay, let me now turn to the public, and that will be my my last thing to review. And then I'm going to open it up for questions and do my best to answer them. And if questions don't pour in, I have plenty more that I can say as well. But I always like the opportunity to respond to questions. I'm going to try to do that if I can. So, what about the role of the public in standing up to the executive branch? Well, our system of government is not set up to facilitate or enable violent resistance to executive branch action, even if it's unlawful. And that's by design. A rule of law system does not want there to be revolutionary action in the streets. So to give you an example of how that can happen, if you think of the January 6th march on the Capitol, that march may have begun as a perfectly peaceful and lawful march, but when the protesters breached the security defenses of the Capitol and entered the Capitol and threatened people and property, that was no longer a peaceful protest of the democratic sort that our system is designed to facilitate. So we don't want to have seen public resistance in any violent form. What is appropriate under our system is nonviolent protest. And depending on your point of view, I think it's fair to say that much of the protest against the Trump administration's actions, particularly involving the deployment of National Guard and particularly involving ICE, has been public action that has mostly been within the bounds of being peaceful. And here I really want to emphasize the Minneapolis, Minnesota protest, and I want to talk a little bit about ICE in particular and its relationship to the end of that story, and also about the role of the courts with respect to ICE. So let me take a half step back and say that when it came to deployment of ICE officers who were authorized to stop people, for example, in Los Angeles, on the basis of people's appearance of being Latino, on the basis of their speaking Spanish, or on the basis of their being present in locations where ICE claims that undocumented people get hired for jobs, the courts failed, signally failed, in historical terms failed, to block that deployment. And indeed, the US Supreme Court upheld that deployment in Los Angeles. And in opinion writing only for himself, Justice Kavanaugh justified that action by saying that it did not count as a violation of the equal protection of the laws, because all that was being authorized were stops to ascertain whether people were citizens. Now, I think that was somewhat counter to reality, because once people were stopped to ascertain whether they were citizens, they were subsequently arrested if they were unable to show that they were citizens. And so, to my view, that amounted to reliance by government officials on discriminatory techniques like guessing at people's race, their ethnicity, and so forth as proxies for their citizenship, which to my mind violates the 14th Amendment in no uncertain terms. I think the Supreme Court's opinion in that case is going to go down in history as a very bad one. I think Justice Kavanaugh will very much ultimately regret having written that opinion, which, to be honest, he didn't have to write. You know, he could have issued no opinion and the court's decision still would have been wrong, but there wouldn't have been quite as much to shoot at in this particular instance. But the bottom line is the court failed. It failed miserably. And that was one of the things that led to the ICE deployments in Minneapolis. In Minneapolis, attempts by the local and state officials of the government to go to court to block what they alleged was effectively an occupation of their territory by ICE were not successful in court. There wasn't a legally cognizable claim to that effect that they were able to convince the courts of. That left the public in the form of protesters as the only real check on deviations from historical practices that, from the eyes of the protesters and from the eyes of many observers, myself included, looked and felt like they could be violations of the rule of law. Now, I want to be really clear here that given that the Supreme Court had authorized at least some of the procedures in question, it's totally credible to say that the ICE actions didn't violate the rule of law initially, insofar as they followed what the Supreme Court had by then said they could do. What might be understood as a violation of the rule of law would have been the specific way that concrete ICE agents applied their practices in Minneapolis. For example, in the killings of the two citizens that happened in Minneapolis. What's noteworthy, and I think it's hugely noteworthy, is that in Minneapolis, in the cold of winter, in a cold place, we saw a sustained, continued public protest to the way the government was operating, a protest that ICE officials claimed was interfering with their ability to execute the law and therefore should be seen as itself unlawful, but that other observers saw as legitimate within their bounds of democracy because it was drawing attention to ICE actions, photographing ICE actions, and objecting to those ICE actions. I think it's fair to say that the deaths of the two citizens emerged in the context of confrontations between ICE agents and protesters that shocked not all, perhaps, but many, many Americans. In particular, there was the irony that the second person killed had a handgun at the initial moment of his confrontation. The handgun was then taken from him by the ICE officers who subsequently shot and killed him. And the irony is that that subsequently, defended by the Trump administration, including by Donald Trump, at least briefly, motivated not only people who objected to ICE's actions, but also Second Amendment supporters who care deeply about the right to bear arms, who believed that this precedent created the possibility that anyone bearing a weapon could subsequently be shot by police, and police could then justify their actions. Now, again, the rule of law is still not working perfectly in those cases. In neither of those cases do we yet have a full and adequate criminal investigation of the conduct of the ICE agents. I'm happy to talk about this in the Q&A, but it's an ongoing serious problem. However, and this is a very big however, and it's maybe the most important thing I'm going to say today, the sustained protest by the public ultimately seems to have motivated President Trump to change the practices in question. So the person who led the deployment was subsequently fired, the head of the Department of Homeland Security was subsequently fired, and ICE is no longer, at least for the moment, engaged in similar attempts to enter communities where they will be met by substantial resistance to seek out undocumented people in a mass level. The point is not that ICE isn't still operating. The point is not that ICE still doesn't engage in sweeps of various kinds. The point is that the self-consciously provocative actions that arguably violated the rule of law have been more or less stopped for now. And the only reason for that, to my mind, is public sustained objection, followed by a political decision by the Trump administration to act according to a different path. Now, why is this so significant in my view? The reason it's so significant is that the protest in its continued basis specified that we lived under conditions in which the emergence of authoritarian violation of the rule of law was not viable. Why was it not viable? It wasn't viable because authoritarianism depends on the idea, fundamentally, that everyone is looking around and seeing if there will be constraint or limitation on the executive branch when it violates the law. And if people think that no one's objecting, then they may think that everyone's afraid to object, or they may think that everyone thinks it's fine. And that does create the conditions in which authoritarianism can emerge. But if people are continuously objecting and they don't stop objecting, the takeaway for the general public is that it's not okay for the administration to continue doing what it's doing, and that free speech still obtains, and that the possibility of democratic response still obtains. And so, seen from that perspective, the protests in Minnesota and Minneapolis can be understood, and in my view, are correctly understood, as a deep vindication of public participation in the battle to preserve the rule of law in the United States. And I think history will reflect that and take that extremely seriously. In closing, the midterm elections are still months away. As I speak to you, it's mid-April. The elections will not come until November. So we're more than 6 months out. And so we're more than 6 months away from knowing definitively how the public in its voting role will respond to events of the previous, by then it will have been nearly 2 years of the Trump administration. It's always hard to ascertain from election results whether there's a response to specific governmental action. You know, the economy is always on the ballot and will be then. There's also historical trends whereby a president in power, typically his party loses seats in the midterm election. One can already anticipate, heated differences of opinion and interpretation of what the results of that election, midterm elections will be, no matter what those results are. So I'm not going to belabor that, but I do think it's worth noticing that part of the picture that we've seen over the last 13 or 14 months, 14 or 15 months, is a story of some degree of public resistance. And it's possible that that resistance will be manifest even more significantly in the midterm elections. So to conclude, Congress does not get a good grade from me. Congress, I think, has been more interested in partisan support for the president of the same party as the majority in Congress than it has been for the preservation of the rule of law. The federal district courts get rather a good grade for doing a very good job. The Supreme Court gets a mixed grade. It's done very well in some areas, and I think that the important decision in the tariffs case sends the right message. The Supreme Court has also not fully supported the federal district courts at a time when they needed it most. And the public, at least the public who has managed to stand up and raise serious and sustained objections the way it did in Minneapolis, to me gets the highest grade and gives me the most reason for optimism in the long run about the preservation of the rule of law. So I'm going to stop there with gratitude to you. It's always challenging to give a Zoom talk because I've got no direct feedback from you, just talking into my screen. But I am now looking forward to looking at my chat and seeing what questions there may be there. And I'll take the first one and hope that the rest of you will post some of yours. First question asked about, let's see, forgive me, I'm reading in real time. What remedies are available when the Trump administration ignores court orders? Well, so that's a great question. In practice, the way things work is that the Supreme Court judiciary has no real independent authority to enforce the law. The President of the United States swears an oath to execute the laws. He's constitutionally bound to take care to make sure that the laws are faithfully executed. And so what the Supreme Court and the courts can do is order specific federal officials to comply with the law. And often, generally, federal officials want to comply with the law. If those officials try to comply and are blocked by the Trump administration, that makes it difficult. And this is one of the reasons that the court has been so careful, for example, about not issuing a ruling that would put the Trump administration in a position where it might directly object to their holding and then not act on it, as happened in the case of the Venezuelan people who were removed from the country. So there's a lot of reliance on the basic structure of the executive branch following the rule of law, and there's no way around that under our system. Another question asks, what options are available to challenge Supreme Court decisions? What will be the criteria to gain standing for decisions like the presidential immunity decision? And here I would just say, to quote Justice Robert Jackson, the late Justice Robert Jackson, he said about the Supreme Court, we're infallible because we're final. We're not final because we're infallible. And what he meant by that was that the Supreme Court gets things wrong, but there's not much that can be done about that except for nominating different justices to the Supreme Court who will vote differently, or in theory, a constitutional amendment, which is extremely difficult to get under our system. So the truth is that, again, the system requires a historical process of the election of a new president and the appointment of new justices and the changing of Supreme Court decisions. So the presidential immunity decision, for example, which I think I agree with the questioner's implication, in my view, empowered this president to violate the law, is going to have to be changed by a subsequent Supreme Court in the future. Another questioner asks me to predict the outcome of the Watson against Republican National Committee case, which is the case about voting by mail, raising the question of whether under federal statute it is permissible for states to, under federal law, it is permissible for states to receive ballots that were postmarked by election day but are received later. And then the other question is, will this have an effect on voting overall? On the second question, I'm going to defer to my colleagues who are experts in the numbers and can tell you how many people really do send their ballots in at that moment in time. I think the bottom line is it'll depend on, in very close races, that might actually matter. Over time, if everybody knows that, then presumably it will have less effect. But in the short term, it could have an effect. How the Supreme Court will rule is not completely clear to me. This is a very close one. It's not that I'm afraid of making predictions. I make predictions about the Supreme Court all the time. I'm sometimes wrong. I like to think I'm right a lot more than I'm wrong. This one is actually a very close case, and I'm not sure which way it's going to come out. What will be required for the U.S. to return to the rule of law, both domestically and internationally? So this is a really hard one. You know, the last time the United States faced a crisis to the rule of law like this, it was Watergate. You know, in Watergate, the country was forced to come to terms with the reality that Richard Nixon had violated the law in outrageous ways, that he'd weaponized the Department of Justice for political purposes. And it took not very long for Congress to respond by enacting new laws and having investigations like the Church Commission that pointed to the problems associated with the politicization of criminal investigation and enforcement. But it took a generation, really, for the Department of Justice to develop norms which, as a matter of custom, enforced the idea that there should be non-political, certainly non-partisan, but really non-political law enforcement in this country. So that takes time, and I think it will take time again. I think it's entirely possible that after the Trump administration is done, there will be a congressional majority that wants that. It's also possible that that could be a bipartisan majority. A lot of that depends on how the Republican Party comes to terms with the legacy of Donald Trump once he's no longer president. A lot of that will in turn depend on whether there's another Republican in office, and if so, it's a Republican who formally bears the Trump mantle, or if it's a Democrat. I do know that to reestablish norms like that requires bipartisan consensus. And one effect of the Nixon administration was that people were so shocked across the both sides of the aisle that we got that kind of recommitment. So I think it will take that, and it will take a deep bipartisan commitment over time. Okay. Are there recent decisions that fundamentally redefine the balance of powers? That's an interesting question. I think the immunity decision, Trump against the United States, had some effect on redefining the balance of powers because it held that the President of the United States, when acting in pursuance of his official duties, cannot be subject to subsequent criminal prosecution for his actions. And that was a decision reached by the judiciary. And although technically it's the executive branch that brings such prosecutions, it brings those prosecutions pursuant to laws passed by Congress. So, in effect, what that decision held was that even if Congress passes laws that outlaw certain conduct on behalf of the president, if the president engages in that conduct, he can't be convicted in a court of engaging in that conduct, provided he did so in the fulfillment of his official duties. So that weakens the powers of Congress and secondarily weakens the powers of the judiciary. That is a fundamental change in our balance. I think the Supreme Court justices, especially Chief Justice Roberts, thought, I believe incorrectly, that by reaching that decision, they were making it less likely that we would live in the kind of banana republic where each president prosecutes a predecessor. I think the court was trying to intervene and solve a political problem, and the court's very bad when it tries to do that. The court just usually gets it wrong. Dred Scott is the most famous case where the Supreme Court thought that maybe it could avoid the Civil War by issuing its ruling, and it issued a ruling that was not only morally repugnant, but didn't stop the Civil War. So I think the court should be careful about trying to do things like that. What are developments we should be watching over the next several years as indicators of where the rule of law wars are heading? Terrific question. We should be looking first at whether the Trump administration continues to take actions that openly violate existing legal norms, or instead takes actions that at least superficially conform with the rule of law. I can't overemphasize enough how early in the days of the Trump administration, the administration took many actions that it could have taken through formally lawful means, and they just skipped doing that. The attack on Harvard was a great example. You know, Title VI does provide for a judicial finding that there's a violation of Title VI, which in turn allows for at least some limitation on funding to the university. And now the Trump administration has filed a lawsuit to that effect. Now, my own prediction, for what it's worth, is that under the First Circuit's principles, the facts alleged by the Trump administration aren't sufficient to satisfy the legal requirement for a finding of Title VI violation, although, you know, we'll find out about that soon enough. You don't need to take my word for it. We can just find out about it when the court ultimately rules on it. But at least that's the legal procedure that the statute provides. Whereas when the Trump administration first suspended funds from Harvard, it didn't even bother to pay attention to the legal procedure. So even if the Trump administration continues to attack targets that it doesn't like, if it does so in a way that is in conformity with the rule of law, that's a good sign for the rule of law. It's a sign that the Trump administration thinks that it shouldn't continue this frontal strategy of attacking the rule of law directly. Same with the tariffs. The Trump administration has other plans for using other procedures to try to enforce tariffs. Those will be challenged in court, to be sure, but the ones that are already being used or say are going to be used do seem to follow legal procedures to a much greater degree than those that have been used so far, and remains to be seen what a court will say about them. So those are the kinds of issues to look out for. The other is when they clearly do take actions that violate rule of law, what will the court do about it? So I would watch the birthright citizenship case closely. From oral argument, it seemed most likely that the court would strike down the Trump administration's executive order purporting to end birthright citizenship. That will be a real win for the rule of law if the court does that, but that's another one to watch closely. What inference do we draw from President Trump's decision to attend the recent Supreme Court oral argument? And in fact, the case where he did so was the birthright citizenship case. Honestly, that is a mystifying one to me. You know, Trump went, he listened to his Solicitor General argue, then he didn't wait for the other side. He got up and he walked out. And the justices paid no attention to him, made no reference to him, didn't act like his presence was particularly noteworthy. That said, he was, I believe, the first sitting president ever to attend oral argument at the Supreme Court, as according to the records as they're known. Perhaps he imagined that his presence would signal the grave significance of the case, but I just don't think that it had that impact. I think that, you know, the justices, including justices whom Trump himself appointed, care about the rule of law. And some of them, particularly Justice Barrett, have come under enormous public criticism and pressure from Trump supporters on the theory that somehow she's too committed to the rule of law and not committed enough to Donald Trump. She is indeed deeply committed to the rule of law, but she shouldn't be subject to criticism for that purpose. It's another indication that one shouldn't think about the rule of law fight as a fight that depends on whether you're a Democrat or Republican. Justice Barrett is deeply, deeply politically conservative. She was, nominated by Donald Trump. She was confirmed by a Republican Senate. And yet, when it comes to rule of law issues, she's been very firm and very much, I would say, in the middle of the court, notwithstanding her deep conservatism. A good example of the fact that whether you stand up for the rule of law is a question of your commitments and your jurisprudence and your values, not a question of the political party you belong to. Someone asks a great question. Am I equating the rule of law with the Constitution? The person says, I would have thought that rule of law, this is Joe Blatt, is a broader concept which draws on history and traditionally shared understandings. Please comment. So you're right that as a shorthand in this talk, I've been identifying following the rule of law with following the commands of the Constitution and the federal statutes as interpreted by the courts, because in our system, those are the institutions that get to determine what the content of the law is. It's true that the idea of the rule of law generally is indeed, as the questioner points out, a broader idea that stands for the idea that we're governed by laws and not by people, not by men. And the idea there is that the law prevails over and above personal loyalties or personal commitments. And then the way you measure whether that's happening is and it's not a perfect measurement, is you try to see whether the laws as written are actually being enforced. And that's why I'm using it in that way. Let's see. I speak as though elections will happen. Am I worried about the midterms being canceled due to some emergency? Well, it's my job as a constitutional law professor who cares about the rule of law to worry about a lot of things. But I don't believe that it is at all plausible that the midterm elections would be canceled, nor do I believe the American public would tolerate it. Does that mean there's not some possibility? That doesn't mean there's no possibility of individual officials in individual places, or even the Trump administration generally, trying to put a thumb on the scale in some aspects of the midterm elections. But I think that would be resisted by officials of all political parties across the United States. This is not based on some idealistic picture of the impossibility of such a thing happening in the United States. It's rather based on a cold, hard look at the political incentives involved. And I think relevant political officials would judge that the public would punish them severely for trying to interfere with a valid, fair, legal elections. We've had now the phenomenon of election denial. It happened, after the 2020 presidential election. And yet we had a not orderly because of January 6th, but a transition of power. And I believe we will continue to have that going forward. Let's see. Good question here. There's a lot of criticism of Republicans. What are your biggest critiques of Democrats in Congress and the Supreme Court with respect to their relation to the rule of law? My critique of Democrats in Congress is the Democrats in Congress have not always done anything like enough to awaken in the minds of their colleagues, Republican and otherwise, that it's the future of the House and the Senate and of Congress in general that's at stake here. That's a hard obligation, but it needs to be done. And the other thing is that members of Congress have to do a better job of reaching Americans where they are, which is largely on social media. And although there are people who are trying to do a better job with that, I think it's fair to say that Democratic politicians are still well behind the Republican Party with respect to making those arguments in the public. And with respect to the justices on the Supreme Court, I think they're doing their best. I think they're facing a very difficult challenge. If every time you get a decision you don't like, you say the rule of law is threatened, the public will stop listening. You'll become the boy who cried wolf. So that's a very difficult thing for the Democrats. And they're not, to be clear, they're Democratic nominees on the Supreme Court, but I understand that that's the questioner is referring to. So, I think that's hard. And in some instances, I've agreed with the justices when they take a strong stance, but I think you can't do it in every case. That's something to look out for. Okay, we've got 1 minute left. I'll close on this. Does the Constitution require a congressional declaration of war prior to the start of hostilities? Well, as written, the Constitution does require a declaration of war. The War Powers Resolution accepts the reality that presidents may begin hostilities on some occasions without authorization from Congress, but it specifies that the war powers clock starts to run, and then Congress must subsequently authorize those hostilities or they become unlawful. And so that War Powers law, the War Powers Act, represents a kind of modern concession made to the realities of what presidents do, and it's a kind of modification of the explicit constitutional requirement. Okay, I'm going to end there with gratitude to all of you, and thank you very much for participating and for terrific questions.
Thank you, Noah. And thank you all for joining us tonight. We hope you'll join us for more signature events in the future. Information on upcoming events, as well as recordings of past ones, can be found at vpal.harvard.edu/vpal events.